Good morning, everyone. My topic of presentation of federalism union state relationship is on a case law named Ajit Mohan versus Legislative Assembly of NCT Delhi Supreme Court AIR July 2021. Factual context of this case. In February 2020, the Delhi witnessed widespread communal riots on 2nd of March 2020. In the wake of these riots, the Legislative Assembly on Delhi constituted a Committee on Peace and Harmony. The Peace and Harmony Committee, under the chairmanship of Mr. Raghav Chadha. One of the objectives of the Peace and Harmony Committee is to understand the factor which cause riots and provide the recommendation to ensure such riots do not happen again. After the Peace and Harmony Committee constituted, it received complaint which suggested that Facebook platform had been used to endanger communal harmony. Thereafter, the 14th of August 2020, the article published in Wall Street Journal titled Facebook Hate Speech Rule Collide with the Indian Politics presented a journal investigation into the role of the official Facebook India, who applied content moderation policies in the partisan manner, enabling hate speech. In this context, the Parliament Standing Committee on Information Technology and the Peace and Harmony Committee issued a separate summons requesting Mr. Ajit Mohan, Vice President and Managing Director of the Facebook India, Only Service Private Limited, and appears before the Vice President and Managing Director of Facebook India, Online Service Private Limited, appears before them, while Mr. Mohan appeared before the Parliament Committee. He refused to appear before the Peace and Harmony Committee on ground of hate regulation or intermediaries like Facebook squarely fell within the legislative domain. The Parliament, upon the refusal and the Peace and Harmony Committee replied with another summons asking Mr. Mohan appeared before them and stated that his refusal was inconsistent with the law privilege of all legislatives. The law privilege of the legislature, which stated constitute Article 105 and 194, enable the Legislative Assembly and Parliament to initiate the proceeding against those who hinder their functioning. In response of Mr. Ajit Mohan filed a petition under Article 32 Constitution before the Supreme Court of India. In the petition, Mr. Mohan, the court to set aside the summons, issue a peace and harmony. While proceeding before court were pending, the Peace and Harmony Committee issue another summons, this time addressed the Facebook India. In the summons, the committee requested that the competent senior representative of Facebook India appears before them. The summons was issued in suppression. The two summons issue Mr. Mohan and it substituted those summons as subject matter of proceeding before the Supreme Court. Broadly, there were two issues before the Supreme Court: whether the peace and harmony established by the Delhi Assembly could summon or non-member threaten them with which privilege, even though they had not interned on the functioning of assembly. Whether the Peace and Harmony Committee established by Delhi Assembly could compel the executive of Facebook to appear as witness, even though the Assembly may lack competence and to enact law and regulated intermediaries such as Facebook. Overview of Facebook. The judgment is noteworthy and chronicling power of legislature, but the judgment also makes several crucial observations how Facebook function, the power Facebook wield in India. The court noted that while the Facebook has played a crucial role in enabling free speech by providing the voice and voiceless and mean escape the censorship, we cannot lose sight the fact that it has simultaneously become the platform to disruptive message, voice, and ideologies. The court questioned whether the Facebook is merely intermediaries when it stated difficult to accept the simplistic approach adopted by Facebook that merely platform using third-party information has to role generating the controlling, modulating, and information. The court used the same line reasoning and rejecting Facebook contention non-appearance would not disrupt the function the petitioner more with their extended role of intermediary can hardly contend that they have some exceptional privilege abstain and appearing before the committee duly constituted by assembly. Apart from this, court was also critical Facebook conduct in other countries. The court stated that internationally, Facebook had to recognize the role in failing to prevent the division of incitement offense of violence in context stated the ethnic cleansing Myanmar and crescendo of the misinformations and post shadow mist of the Facebook employees help fuel violence. The platform similarly applies for lack of the serious response and evident sign of the abuse. Platform Sri Lanka and again stated have stoked widespread violence in 2018 in the country had acknowledged it needs to regulate though the exact method still unclear and prerogative of law making authority. Judgment of this case on 8th of the July 2021 Supreme Court bench consisting of the three judges Sanjay Kishan Kaul, Dinesh Maheshwari and Harish Case Roy pronounced their judgment on the writ petition filed by the Mr. Ajit Mohan. The court rejected Mr. Mohan contention that the Peace and Harmony Committee could not summon a non-member investigate an issue on which it lacked the power to enact law, and premises of the court decision was that the function of legislative is not restricted to enact laws. The court noted the Walter Bagehot's and seminal works, English Constitution, where the elucidate five significant functions of legislature: elective, expressive, and teaching, informations, finally legislative. Thus, the court held that the function of Delhi Assembly thereby committed wider than enacting laws, and hence they could conduct an inquisition into events leading Delhi riots. To the end of the Peace and Harmony Committee was justified summon executive of Facebook. Mr. Rahul Narayan has made similar argument here, where he has stated that the political assembly is voice of the people of state. Their discussion are an express of the popular will, atomic energy in exclusive pressure of the union. Does that mean state assembly could inquire the possible ecological implications, and nuclear waste state within the state. The court also noted that the concerned Mr. Mohan and Facebook India were premature since the Peace and Harmony Committee had only summoned them, had not even asked them to show cause their breach of privilege. At the same time, the court also held that the Peace and Harmony Committee could not recommend action against a person against whom the incriminating evidence found because it was within power of assembly. The court noted recommendation against the person was akin and policing which was within the remit union government in national capital territory of Delhi. The representative Facebook can refuse answer the question posed by the committee which was strictly within domain of central government. Conclusion of this case, the decision of the three judges bench of Supreme Court is welcome. In 2020, the committee began much needed inquiry into event that led Delhi riots. The court decision allowed the committee to continue working in the direction. Importantly, the committee is not restricted from evaluating the role of Facebook in the riots and finding the report in the earlier mentioned and Wall Street Journal article the necessitated an inquiry into whether Facebook intention unable to spread the hate speech on its platform. Previously, on 17th of August 2020, IFF had sent the representation to Parliament Committee asking them to summon Facebook senior management. As mentioned earlier, Parliament Committee did summon Mr. Mohan, who duly appeared. We are glad that the Delhi Assembly can also conduct similar exercise. And finally, Supreme Court held that this is no dispute about the right of assembly or the committee to proceed on ground of breach of privilege per se. The power of compelled to attendance and initiating privilege proceeding is essential power. The member and non-member can equally be directed appears before the committee dispose on oath. In the given fact, the case issue of privilege is premature. Having said the insertion para 4 and the term reference taken along the press conference, chairman of committee could legitimately give rise to apprehension in the mind of the mind of petitioner, and account of which a caveat has been made, and convincing the clash between privileged power and certain fundamental rights is also promptory and present case. In any case, the larger issue of the privilege which right of the free speech and silence and privacy of the context of part 3 of the constitution still large and view of reference to the large. The Assembly admitted does not any power to legislate on aspect of law order to the police in view to entry 1 and 2 of the list 2 7th schedule inter alia being excluded. Further, the resolution or intermediaries is also subject to covered by the IT Acts. In 7. The Assembly does not only perform the function of legislative, there are many other aspects of governance which can form part of the essential functions as legislative assembly. And consequently, the committee, in large context, the concept of peace and harmony goes to beyond law and order. Police, more in view of the ground of governance, is being hands the Delhi government. Para 4, the term of reference does not survive of any opinion. The committee, it will not be permissible for the committee encroach upon any aspect strictly within the domain of entries 1 and 2 list or second 7th schedule as per any representative or petitioner would have right to not answer. That bring us to the end of this segment. The writ petition accordingly dismissed of the subject matter for subject to term aforesaid. Thank you so much.